Meeting. Brother. You come.
No, I've got, been on the phone with Guy.
Yeah. You ready? All right. We will call the meeting, the September 12, 2024 meeting of the Putnam County Board of Zoning Appeals to order, and we'll start with the Pledge of Allegiance. Mr. Hodge, would you take the roll, please?
Sure. Mike Stewart's,
Here.
Jared Tolley,
Here.
Tony Hodge here. We have a quorum.
Okay, let's start with action on the June 26, 2024 meeting minutes. That was a special meeting. I believe that was solely to comply with the statute that we had a meeting.
I'll move that the minutes from the June 26th meeting be approved.
Second.
All in favor?
Aye.
2 ayes. Minutes are approved and signed. Next agenda item is citizen concerns. Are there any citizen concerns unrelated to the Kanawha Valley advertising variance request? Does anyone have a conflict with respect to the Kanawha Valley, does any member of the board have a conflict with the Kanawha Valley advertising DBA WV outdoor zoning variance application?
No.
Or do I? We'll move to the public hearing portion of the meeting. All comments should be directed to the Board of Zoning Appeals. Please request to be recognized by me prior to making public comments. Also, prior to making comments, please stand at the microphone and adjust it. Be sworn in and state your name and address. The board will hear from the applicant and any expert witnesses. Each speaker from the public will be allowed to speak once, and the comment time will be limited. The public hearing is held to receive comments. It is not a forum for debate. David, we'll turn it over to you.
Thank you very much. The Kanawha Valley Advertising DBA West Virginia Outdoors has submitted a zoning variance application request. The applicant requests permission to demolish an existing static billboard signage, off-premise sign, from locations on parcels 25 and 25.25 of Tax Map 184, then construct a new digital billboard signage, an off-premise sign, on parcel 25.26 of Tax Map 184. Off-premise signs are prohibited under Article 1400.05K of the adopted zoning ordinance. The property is located near the 817 and Route 34 intersection in Winfield and is zoned C2, high-density commercial. Ordinance authority for tonight's discussion comes from the following: Article 150, definitions, Article 650, C2, high-density commercial district, Article 1400, signs, Article 1800, non-conforming provisions, and Article 2100, Board of Zoning Appeals. Article 150.02, definition of terms, defines sign changeable copy as a sign on which message copy is changeable, also called a reader board sign or electronic variable message sign, or an EVMS. Sign copy on a changeable copy sign shall be static at all times, change instantly between static copies, and not include full motion video, flashing, fading, scrolling, blinking, pulsing, animation, or movement of any kind. Article 150.02 defines a nonconforming sign as a sign which lawfully existed on the effective date of this ordinance or amendments thereto, and which does not conform to the provisions of this ordinance. An off-premise sign is defined as a sign not located on the premises or the use or activity to which the sign pertains. A nonconforming use is defined as any legally established or created use which does not conform to the applicable regulations of the district in which it is located, either on the effective date of this ordinance or as a result of any subsequent amendment thereto. A variance is defined as a modification of the strict terms of the relevant regulations of this ordinance where such modification will not be contrary to the public interest and where owing to conditions peculiar to the property that are not the result of the action of the applicant, a literal enforcement of the regulations would result in unnecessary and undue hardship. Article 1400.05 prohibited signs, letter K, states that all off-premises signs are prohibited, except those mentioned in section 14.10, and those permitted off-premises signs are community event signs and off-premise directional signs. Article 1400.11, nonconforming signs, letter A, states that a nonconforming sign may be structurally altered, provided that such structural altercation does not result in, 1, an increase in the total sign area or any dimensions of the sign, including height, or 2, any increase in the degree of nonconformity of the sign. Structural altercation of a nonconforming sign, which results in a decrease in nonconformity, is prohibited. Under the same article, letter E states replacement of static nonconforming signage with 100% electronic variable message sign is permitted. Article 1800.01 statement of legislative intent states, it is the intent of this article to A, control construction of structures on nonconforming lots, B, restrict expansion of nonconforming structures used for a permitted use, C, encourage the eventual elimination of nonconforming non-residential uses, and D, prevent the reestablishment of nonconforming uses after they are moved or abandoned. 1800.04, nonconforming use of structures or land states that, letter E, states that no nonconforming use of land or structure shall be moved in whole or in part for any distance whatsoever to any other location on the same or any other lot unless such shall conform to the regulations of this ordinance for the district in which it is located after being moved. Article 2100.05A, powers and duties, number 4, letter B, states, relative to the Board of Zoning Appeals, states that under no circumstances shall the board grant a variance to allow a land use not permitted under the terms of this ordinance in the district involved, or any use expressly or by implication prohibited by the terms of this ordinance in said district. 2100.08, procedure for a variance request, letter D, states that the Board of Zoning Appeals shall grant a variance to the zoning ordinance if it finds that the variance, 1, will not adversely affect public health, safety, or welfare, or the rights of adjacent property owners or residents. 2, arises from special conditions or attributes which pertain to the property for which a variance is sought and which were not created by the person seeking the variance. 3, would eliminate an unnecessary hardship and permit a reasonable use of the land. And number 4, will allow the intent of the zoning ordinance to be observed it's substantial justice done. Excuse me. All right, pertinent facts. On July 30th, 2024, Kanawha Valley Advertising, DBA West Virginia Outdoors, submitted a Putnam County sign permit application, number 13163, and a Putnam County zoning appeal variance application. The applicant requests permission to demolish an existing static billboard signage, off-premise signs, from locations on parcels 25 and 25.25 of Tax Map 184, then construct new digital billboard signage, AKA off-premise sign, on parcel 25.26 of Tax Map 184. The property is located near the 817 and Route 34 intersection in Winfield and is Zone C2, high-density commercial. The application and disclosure statement are included in Attachment A. Parcels 25, 25.25, and 25.26 are owned by AJ Investments, LLC. The property owner intends to develop these properties as commercial, which will necessitate new or improved access points onto Winfield Road. In doing so, the existing billboard signs must be removed from their current locations. The property owner desires to offer West Virginia Outdoor a new billboard location on their property instead of buying out the current contracts. Off-premise signs are prohibited under Signage Article 1400.05K of the adopted zoning ordinance. In 2022, the Supreme Court of the United States made a ruling about off-premise signs. An article in this regard from the American Planning Association is included as Attachment B in your packet. The applicant submitted a site plan and aerial photograph indicating the two existing billboard locations. You can see Attachment C in your packet. The existing western location is labeled as current billboard location. This 30 plus or minus foot tall sign is located on parcel 25.25 of Tax Map 184 at the Route 34 817 intersection and has two sign faces which total 506 square feet. This billboard offers static advertising. The existing eastern billboard location is labeled Other Existing Billboard. This 20 plus or minus foot tall sign is a back-to-back V-shaped formation billboard with two sign faces which total 506 square feet, located on parcel 25 of Tax Map 184, and is near the entrance of the current contractor laydown yard off of Route 817. This billboard also offers static advertising. The location of the newly proposed billboard is shown as the westernmost delineation. If approved, this new billboard will be a back-to-back V-shaped formation with two sign faces that total 484 square feet, located on parcel 25.26 of Tax Map 184, and will be 20 feet in height. This billboard would offer digital advertisement. The applicant submitted written correspondence that includes additional sign details, which you can see in Attachment D of your packet. Google Earth photographs on Attachment E show the existing billboard signage at both locations. The first photograph shows the location described as current billboard location. The second photograph shows the location described as other existing billboard. The applicant submitted a photograph of an existing billboard in Parkersburg, which is visually similar to the newly proposed billboard. See Attachment F. The proposed billboard in Winfield would have the same size digital screen, which would be 11 feet by 22 feet, as the one depicted in the photograph, however, would have a lesser height than the pictured example. A copy of the lease agreements for the existing and proposed signage are included as Attachment G. A zoning map is included as Attachment H. The subject parcels are outlined. All unincorporated and zoned parcels in the area are C2 high-density commercial shown in red. The parcels are directly abutted by the following. The northern parcel boundaries of Tax Map 184, parcels 25, 25.5, and 25.6 are abutted by the Kanawha River. Tax map 184 parcel 1 is located to the west and operates as Winfield Locks and Dam, as well as an AEP facility. Tax map 184 parcel 25.9 and 25.29 are located to the east with business operations of a tire store plus a bar and grill. Tax map 184 parcels 3, 4, 5, 6, and 25.2 are to the south and operate as restaurant, car wash, and personal service establishments. The applicants submitted written correspondence as a response to Article 2100.08D, factors for considering a variance request. You can see that in attachment I. Public comments were submitted by the applicant, which you can see in attachment J. A public hearing notice was mailed to abutting landowners within 250 feet on August 8th of 2024. The variance public hearing was legally advertised in the Hurricane Breeze on August 9th of 2024. A notice of public hearing was placed at the subject site on August 23rd of 2024. To briefly wrap up my comments, we're not talking about signage for advertising land uses located on this property. We're talking about off-premise signs or billboards that advertise businesses or services not located on this property. Billboards are prohibited in the zoned area of Putnam County except for uses as community event community event signs and/or directional signs. AJ Investments LLC owns the property at 13288 Winfield Road that encompasses 3 tax parcels. The owners hope to develop 3 business locations on the 3 parcels with new and/or improved access points on the Winfield Road. Both existing billboards will need to be removed. Because both billboards existed in their locations on the adoption date of the zoning ordinance, they are legal nonconforming. They may remain as long as the degree of nonconformity does not increase, as stated in Article 1400.11, nonconforming signs in the zoning ordinance. This article states that a legal nonconforming sign may not increase the total sign area or any dimension of the sign, including height. They may not increase the degree of nonconformity of the sign. Structural alteration of a nonconforming sign which results in a decrease in nonconformity is permitted. Replacement of static nonconforming signage with 100% electronic variable message sign is permitted. The property owner desires to offer West Virginia Outdoor a new billboard location on the property instead of buying out the current contract. If the BZA approves this variance request, West Virginia Outdoor will move both existing billboards and terminate those leases. If so, 1 new billboard will be erected 195 feet to the west that will be less square footage, shorter in height, and will be digital changeable copy instead of static. Key questions to consider. May a billboard be removed from one location on the property and be reconstructed on another area of the property and maintain its legal nonconforming status? Does the fact that 2 billboards may potentially be removed and be replaced by 1 reconstructed billboard with a decrease in nonconformity, such as size, height, and type of message, need to be taken into consideration? Does the fact that the property owner has the option of buying out the current contracts, which would result in both billboards being removed, does this need to be considered? In which case, 2 legal nonconforming billboards in a zoned area will be removed. After your discussion, you can refer to the variance worksheet at the end of your packet, and I'll be glad to answer any questions you may have.
Anyone have any questions? Mr. Hodge? For those in the audience and all of the people, I'm sure, who are watching us online, layman's terms, why are we here today as opposed to going through the details?
All right.
Statute.
Well, we have 2 legal nonconforming signs, and the ordinance says that these billboards are not permitted under the current zoning ordinance. However, the proposal is to eliminate the two existing static signs and create one sign with an electronic message, which is permitted. But the question is, does the non-conforming status remain if it is deconstructed and reconstructed in another location? If you tear it down, according to the ordinance, well, then you can't put up a new one because they're not allowed. However, they're there existing. Can two turn into one and remain a legal non-conforming structure?
Quick question. These signs are prevalent on digital signs.
What is it? I'm sorry?
They're prevalent on Tays Valley Road, correct?
I'm not that familiar with, with all the locations, but if they are, they were more than likely in a legal non-conforming situation, much like the two that are there now, which were probably erected prior to the zoning ordinance.
Yeah, I can think of two right now that are being used on Tays Valley Road, and I was just wondering if we've already gone through this before. And,
I asked the same question of my staff. I've been here almost 3 years, and I haven't had the situation arise. And I asked if they've experienced this type of variance, and to my knowledge, we haven't had this type of variance come up, request.
Okay.
So that's an interesting question, which I don't have an answer to.
Questions? Looking out, I see some West Virginia Outdoor T-shirt or polo shirts out there, so I'm assuming you're the applicant. So does anybody wish to speak for the applicant? As a reminder, you may have to adjust the microphone so that you're speaking into it. Be sworn in and then state your name and address.
Where do I swear in?
And the court reporter will swear.
Okay. My name is Lawrence Silbernagel. I'm sorry, Lawrence Silbernagel? Yes.
Please raise your right hand. Do you solemnly swear or affirm the testimony that you give today is the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you. Good evening, sorry. Like I said, my name is Lawrence Silbernagel. I'm here representing West Virginia Outdoor. We have been at this location since 1996 is when we constructed this billboard, the main one that we're talking about. And really, all we're looking to do, I know we are technically asking for all of these variances, but he's summed it up pretty well. Basically, all we want to do is do the conversion that you all have outlined in the code, where we're taking an existing static and converting it to a digital, which is allowed. Unfortunately, for my landlord, in order for them to give me the new lease, they really need that board to be moved just down the road, like 150 feet. It's staying on the same parcel. I think he said 195 feet, actually, sorry. It's staying on the same parcel, and then we're actually going to eliminate another billboard down the road too also. And that's going to allow them to install a new entryway right at that intersection there to get into these three businesses that they're trying to develop at this location. So that's really the essence of what we're doing. I mean, technically we are asking for all of these variances, yes. But really the spirit is we just want to do the conversion that you have outlined in the code. And I'm happy to answer any further questions that you all may have.
Questions?
None.
So you work at West Virginia Outdoors?
Yes, sir.
What's your position?
I'm the director of leasing.
As the director of leasing, I assume you deal with lots of various locations where billboards and signs are located.
Yes, sir.
When you talk about a location, how do you define that internally? Do you define it as the site where a billboard is located, or do you define it as the parcel on which a billboard is located?
Really,
If at all. It's a very narrow question.
I mean, honestly, it's maybe internally it's identified by possibly a landmark, an intersection, an address. It doesn't necessarily have to be a specific parcel, but then when I write a lease, obviously I write it for a specific parcel. So
is your lease, for example, the current lease that you have, and I think it's in here, I just don't recall. Do you know if it is defined, if it describes the entire parcel, or does it describe particular section on it?
I believe, I would have to look at it in front of me, but I believe it describes the specific parcel 20, I believe it's the parcel that we're asking for is how we wrote it, because this is a new lease that we agreed to that was kind of contingent on us getting this variance.
What about the existing lease from?
The existing lease, it would have been written, I believe, just as the address, because it was before my time.
Okay. Any questions?
None.
Thank you.
Thank you.
Is anybody else speaking on behalf of the applicant? Any members of the public wish to speak on this issue? Okay. With that, we will close the comment section, and I'll move that we adopt the packet that we received, which includes the summary as well as the applicant's application for variance request, statements of Mr. Call, and statements of Mr. Silver Nagel as our factual record.
I'll second.
Second.
All in favor?
Aye.
2 ayes. That will be our factual record for consideration of this variance request. What I think may be easiest, we now have a factual record adopted. We can typically do this one of two ways. We can either discuss the facts that we think support a decision one way or another, or we can go through the criteria that we have to consider for a variance request. Anyone have a preference?
I do not.
Let's go through each of the criteria. I think that might inform some of our discussion. First criteria to consider is the variance will not adversely affect the public health, safety, or welfare, or the rights of adjacent property owners or residents. Any thoughts on the relevant facts that we've heard today that may, or that were contained in our packet that inform this criteria?
I'm a yes.
Yes.
Any thoughts on the factual basis for why the request will not adversely affect the public health, safety, welfare, and rights?
No, I just think the electronic use is permitted, the size of it, not conflict on anybody's view or anything like that. We haven't heard testimony in that regard, so follows that it would not adversely affect the public health, safety, or welfare or rights.
It also seems it's not going to create any obstruction to the road, for example. It's not going to overshadow any neighboring homes and adjacent landowners or residents who receive notice and not comment at least negatively about the variance request.
I think it's going to make the intersection probably safer, rather than somebody pulling on to 817 and they're reading the billboard pulling on to 817. Now with the sign down the road, I think it'll be a lot better for the intersection.
Okay. With those relevant facts, keep in mind as to whether you're a yes or no as to whether that criteria is met, and we'll talk about those in a moment. The next criteria to consider is the variance arises from special conditions or attributes which pertain to the property for which a variance is sought, which were not created by the person seeking the variance. This one sort of brings to mind some of the things that Mr. Call noted about, this is moving on the same parcel. What impact does that have? We're moving 2 and going to 1, so that's decreasing the nonconformity. So those are some of the questions that come to my mind with respect to this criteria.
Yeah, I mean, I would agree with how you describe Mr. Hall described it. And I guess the issue was not created by the person seeking variance. Whoever stands out to be there.
This is sort of a nuanced consideration because we've got tearing this down, placing it, okay, but they're moving it, so that creates a question of, is that replacement or is that a new billboard? Mr. Silvernagle testified that at least internally, they knew this likely as an address, is what they would have done in 1996, maybe description now, in the proposed lease, so it seems like at least internally, they define the site as the entire parcel, not the point on a parcel or something located. Maybe the next question is, it seems that the removal of two being reduced to one does decrease nonconformity.
I really don't even see a problem. As far as conformity, we have these signs already used. Davis said, his knowledge, we've never gone through this procedure before. And I don't see how we can let somebody else do it, not let these folks.
The narrow issue I think that we have is that it's being moved, for example, from the intersection there between Giovanni's and Wendy's to an edge of the property. That's the difference between the others. The question I think is, does that movement conform with the criteria that we need to consider to grant variance for this?
Mr. Tilley, may I insert one thing? Mr. Stewart's question earlier, stating that he sees a lot of these in the valley. If you have a legal non-conforming sign and you don't move it or tear it down and build a new one, if you simply take the static message away and replace it with a digital message, that's fine.
Okay,
So that may be a better answer to your former question.
okay.
Okay.
Well, I can remember them, they took the whole pole down and put a new pole up and put the sign on top of it.
Right, but now if you tear it down, a non-conforming situation, and build a new one, technically by the ordinance, that's not allowed.
Okay.
Yeah.
Any further discussion on the second criteria, at least as to the relevant facts to consider? The third criteria to consider is the variance. The question asked, the variance would eliminate an unnecessary hardship, permit a reasonable use of the land. So the questions here are, what is the hardship, the unnecessary hardship that would be eliminated, and is this, would this variance allow reasonable use of the land?
I think it's a win-win for both the owner of the property and the sign company. Relatively simple. I say it's a win-win.
At least for the second part, what my mind went to is the reasonable use of the land is moving this will allow development on this parcel with, I think, like I said, 3 businesses. The question for me becomes, at least in my mind, is whether this eliminates an unnecessary hardship. Any thoughts on the factual basis that would support that elimination of an unnecessary hardship? One of the issues, Mr. Call pointed this out, is what is the impact of having to buy out the existing contract for the land? I wonder if that is unnecessary hardship. come back to that when we discuss the criteria to vote. The final criteria is the variance will allow the intent of the zoning ordinance to be observed and substantial justice done. Any discussion on the relevant facts packet for this evening that support or refute this criteria.
Article 1800.04, Mag E, in regards to moving, no non-conforming use of land or structure shall be moved in whole or part for any distance whatsoever to any other location of the same or any other lot unless such use shall conform to the regulations of this ordinance. So, difficulty with that one. And then legislative intent to encourage the eventual elimination of non-conforming uses and prevent the reestablishment of non-conforming uses. Those two things, factual record, anything false.
See, to me, there's some tension between reducing, but it's not eliminating. We're reducing from 2 to 1, so that's where the tension concerns that I would have.
That's a minor. The other criteria I'm fine with is this last one, intent of the ordinance. I'm not sure.
Yeah.
Again, I really have no problem with what we're trying to do here. We're going to create a situation if we don't move the sign across the street and allow for the entrance. Right now, we got a stoplight to help that situation. If we don't move the sign, that means their entrance is going to go down the road close to the 34 exit. And people will be turning in to the development, and we'll be stopping traffic. It just really will break up the flow of everything, right in that little intersection. And they're moving that sign completely out of the intersection area. I think it's probably something we need to do with progress. I mean, the lighted signs are here. We may be a farming county, but we still need to keep up.
I think, part of the intent, this goes back to attention, is that this would eliminate at least one non-conforming sign. It sort of takes 2 to 1, so there is that elimination. And substantial justice, in this case, it allows the development to be done, it allows the contract that's existing to be continued. It seems to me to be a fact that's relevant as to the fourth criteria. Any other factual discussion that we would like to consider with respect to these criteria? I would move that we adopt as our findings of fact the discussion that we just had, as well as the entire factual record that we previously adopted. All in favor?
Aye.
2 ayes. That will be our approved findings of fact. So we walked through the criteria with a discussion of the relevant facts. If you have answered no to any of the criteria listed in the worksheet, which comes from the ordinance, you should vote not to approve the variance. Any further discussion about the criteria, the facts, or the application?
Done.
Anyone wish to make a motion?
Do we need to discuss our yes or no's or?
I think we've done that in creative record that's sufficient, based on the discussions that we've had, as long as we are prepared, we feel we have an adequate factual basis, or understanding of the factual basis to vote
That's the variance.
Mr. Stewart's has moved to grant the variance of Kanawha Valley Advertising as requested. Second?
I made the motion, so.
Well, I'll second Mr. Stewart's motion. Any discussion? All in favor? Put me in a tight spot. Have to vote. My view of the criteria, I think, given the split vote, I think we should maybe discuss some of the criteria, and continue to build the record. Mr. Stewart's, is your consideration a yes, I assume, for each of the criteria? Mr. Hodge, what is your, just so that we can build the record, I'm not asking you to change your vote, just so that we can build the record, what is your concern with respect to the criteria?
Well, as I said earlier, I have a problem with the fourth item on our sheet here, that the intent of the ordinance is being observed. I think the intent is to eventually remove non-conforming signs. And in this instance, that could happen, but it seems that while we are moving two, I agree, we're adding one, at least if I understand the facts correctly. And I just don't think that fulfills the intent of the ordinance. 1800.04E, and then the legislative intent was 1800.01 C and D, is what I'm looking at. And I guess you could argue, moving is item E there in 1800.04, are we moving, does this mean moving an existing sign, actually picking that physical sign up and moving it? I don't know, but what I seem to understand is the intent of the ordinance. Might have to be a no on that particular criteria.
Your view is the intent is elimination, not reduction.
That would be my view, yes. Legislative intent says encourage the eventual elimination of non-conforming uses. And then B, in legislative intent says prevent the reestablishment of non-conforming uses after they are removed or banned. And I feel like, yes, we are removing two, but then we're reestablishing another. I just don't think that fulfills the intent of the ordinance. And I'll just make a remark, it's not necessarily an opinion. My personal opinion may differ, but I'm just looking at what the ordinance says and what I'm supposed to do.
I think given the plain language of Article 1800.04, which states, in the zoning ordinance for the zoned unincorporated areas of Putnam County, West Virginia states, a use of part or all of a structure or land which is not permitted under the applicable zoning district regulations of this ordinance, but which is lawfully established on the effective date of this ordinance, shall be termed a non-conforming use. And I think that's what we have with the existing billboard. But the ordinance goes on, such use may be continued so long as otherwise lawful. It shall be subject to the regulations below. One of those regulations is no non-conforming use of land or structure shall be moved in whole or in part for any distance whatsoever to any other location on the same or on another lot unless such use shall conform to the regulations of this ordinance for the district in which it is located after being moved. And because it's not being moved to an area outside of the zoned area, I think my initial thought was that this was, would be permissible, may be permissible because it's being moved on the same lot. That may be how the applicant defines their site, which I think is relevant. However, I think, Mr. Hodge, you are correct that moving it, quoting exactly, any distance whatsoever would not conform. And I share your view. It may not be my personal opinion, but my view on what the ordinance says is that I would vote no. So with that, the variance request is denied. Move that be authorized to complete order. The board voted to deny the application. All in favor?
Aye.
And I would move that I be, have permission to execute. That, yes. Motion's been made and seconded. All in favor?
Aye.
2 ayes. That motion is passed and executed. What I would ask is, Mr. Clough, you could let the applicant know what their appeal rights are and those timeframes so that they're aware. Moving on to the next agenda item, which is a staff report.
Okay, first of all, I would like for us to welcome Ms. Sandy Miller back. She has, former director, obviously, and she's helping us out on a part-time basis in a transitional period. Couldn't be happier. Fantastic. So,
I, for one, was very happy to see Sandy when I
Yeah.
walked in. And Sandy, since I was on the planning commission, and then when I moved to the BZA. So it's great to see you. And
okay, real quick on the staff report. The main thing for us to talk about tonight is, well, first of all, our next scheduled meeting date of October 10th. We currently do not have anything scheduled for public hearing. We probably will in November, but as of right now, nothing in October. But the one thing we do need to discuss tonight is the second reading of the proposed addendum to the bylaws. We did the first reading on June 26th. This will be the second reading of this proposed amendment, and being the second reading, you can make a motion to accept or deny this proposed amendment to the bylaws. This is a proposal to amend Article 3 Meetings, Section 1, Regular Meeting, to comply with West Virginia Code 8A-8-5. And it states, "The Board of Zoning Appeals shall meet monthly whenever there is an agenda item for their consideration, but at a minimum, should hold a meeting semi-annually as opposed to meeting quarterly. So basically, if there's a string of months where we have nothing on the agenda, we simply, to meet West Virginia Code, we have to meet 2 times per year or every 6 months as opposed to quarterly.
I'll make a motion to approve the bylaw changes as presented to us.
Second that.
Motion been made to accept the bylaw changes as were just read, made to comply with West Virginia Code, section 8A-8-5. All in favor?
Aye.
2 ayes. Bylaws are done.
That's all I have.
That's all you got? All right. The unfinished business. New business. I move we adjourn. All in favor?
I have a hearing notice that was about, the TA operating and submitted as a variance that was going to be on the agenda today.
That one had to be moved from the agenda because there was, I had a conflict with that particular applicant, and we didn't otherwise have a quorum. I apologize, didn't receive notice that had been changed. That has been, I think, has that been rescheduled?
It will probably be in November because we have to rerun the ad. So it's a 30-day ad, and then we have to establish that we'll have a quorum. So as of right now, it should be on the November agenda.
Okay. And what date in November is that?
14?
That should be rescheduled for November 14.
Okay, perfect, thank you.
Thank you. Very, very sorry that you had to sit through the whole meeting. We're adjourned. I think we're now adjourned.